My name's Ellie Turnbull. I'm a Human Rights Officer at the British Institute of Human Rights. Firstly, the really crucial points that I want you to hopefully take away about human rights is firstly, human rights are the law. So you'll see in the middle there the Human Rights Act. That's the law that protects our human rights here in the UK. Human rights are the law, just like any other law. So it's important, I think, to remember that when we're thinking about human rights. They're not just sort of best practice. They're not a sort of fun additional project. If we are sort of maybe challenging things using human rights, or if we're asking for people's human rights to be respected, or just asking for the law to be upheld. Human rights are essentially the rule book for governments, and in the UK, in terms of the Human Rights Act, also public services, so things like police, NHS, local authorities, all these public services. They're the rule book for how we can expect to be treated anytime we're sort of meeting with, talking with, accessing services, or interacting with public services. But it also goes a wee bit wider than public services because the Human Rights Act also says it protects. The Human Rights Act can be applied whenever we are accessing services or interacting with a service that's performing a public function. So what does that mean? So if we can imagine a care home, for example, it's a private care home, and some of the people that are there, the care is being paid for or arranged by a local authority. So there's that connection with a public service, and by providing that care, the private company is performing a public function. So the Human Rights Act would apply there as well. So it's supposed to sort of stop a rights gap, so that whenever there's things that we would maybe traditionally see as public services, be where it's health or care, things like that. Now, of course, we see more that charities and private bodies, private companies and things are providing those services. So it's supposed to protect us there as well. Really crucially about human rights, some rights may be limited. We've all sort of seen over the past year or so that our rights, such as the right to family life, sort of ongoing contact with our family members, has been limited for all of us. So that can happen sometimes. But as I said, human rights are about this rule book. They're about this basic standard of how we should be treated by public services, by the government. So if there is going to be a decision that's going to limit or impact our human rights, that's a big deal, essentially. So if a decision maker is making a decision that's going to impact one of our rights, they have to think about a 3-stage test and make sure that all the criteria in that test is passed. I'll tell you more about that in a second. But crucially, human rights should be respected, protected and fulfilled at all times. And human rights are for everyone. We don't have to pass a test. We don't have to behave well. We don't have to do something good to get our human rights. We just get them because we are humans, we are alive, and we are, if in the UK, protected by the Human Rights Act. So it doesn't matter where we're born, all over the world. If we're here, we're in the UK, and we're alive, then we are protected by the Human Rights Act. Human rights are for everyone. So if we want to think about why we have human rights and how they work, it's really important to think about where they come from. So the first sort of idea about human rights coming together as a sort of set group of ideas, that happened after the Second World War. What happened then was the international community came together as the United Nations. You sometimes hear that called the UN. So they came together, and that was sort of governments from all over the world, and they said the terrible, terrible things that happened in the Second World War, we want to make sure that they never happen again. So they made this rule book, this set of ideas, rules, values for how any one of us can be expected to be treated by the government in the country in which we are in. And this sort of set of rules was called the Universal Declaration of Human Rights. So that was just in the years following the Second World War that this was agreed upon. That was great because it was the first time that the international community decided on this set idea of values and rules that we called this Universal Declaration of Human Rights. Now, if we move forward a couple of years to 1950, that's when the Council of Europe set down the European Convention of Human Rights. And that took lots of the ideas, lots of these rules, lots of these values from the Universal Declaration of Human Rights, and it made another document called the European Convention of Human Rights. And that applies across all the countries of the Council of Europe. And the really important sort of step forward with this is that there was a court system attached. So if you see that picture in the centre of the screen, it looks a little bit like a spaceship. That's European Court of Human Rights. That's in Strasbourg in France. And what that meant was that if somebody in one of the countries of the Council of Europe, so somebody in Spain or somebody in the UK or somebody in Poland, felt as though their human rights weren't being respected by the Spanish government or the UK government or the Polish government, then we could ask that court, the European Court of Human Rights, to look at that. They would look at the European Convention of Human Rights, look at the rights there and think, is this a human rights breach? So that was really important because it meant there was legal accountability. If we felt our human rights were at risk or they were being breached, we could question that and take it to court. Something really important to know about, especially sort of in the past few years, is that the Council of Europe is not the EU, the European Union. Council of Europe and the EU, the European Union, are two different bodies. And as much as we've sort of left the EU, Brexit is sort of ongoing, we are still a member of the Council of Europe. So we can still bring cases to European Court of Human Rights, and the European Convention of Human Rights still applies in the UK. So then if we fast forward almost 50 years to 1998, that's when the Human Rights Act was passed. And that is UK law, and it covers the whole of the UK. And what that did essentially was take all the rights, so you hear them called rights or articles, such as Article 2, the right to life, of the European Convention of Human Rights, and pick them up and put them in UK law. So now it's also Article 2, right to life of the Human Rights Act. So that's what we'll focus on because that's the main way that our human rights are protected here in the UK. Lots of you will be from different places throughout the UK, so I just wanted to talk really quickly about human rights and devolution. So the rights in the Human Rights Act are part and central to the devolution arrangements in Northern Ireland, Scotland and Wales. And each devolved nation has a range of issues for which it is responsible. So, for example, healthcare and education, those are often the responsibilities of the different devolved nation governments. So the Scottish government or the Welsh government and so on. And many of these areas impact on our human rights. So lots of these decisions that have to be made I'll use Scotland as an example because I'm Scottish, by the Scottish government are directly sort of impacting on our human rights because that's where we see human rights issues and concerns maybe arise in health and care and education, things like that, because that's where we interact with public services. These devolution arrangements mean that the different parliaments and assemblies can't pass laws which may be incompatible with convention rights, which are the rights in the Human Rights Act. So what that means basically is if one of the devolved nations, so if Scotland or Ireland or Wales, if the parliaments or assemblies there pass a law and then the law is found to be incompatible with human rights, with one of the convention rights, it can be disapplied. So that's a bit different in how it works across the UK, because in Westminster, if laws are passed by the Westminster government, what happens is if it's found to be incompatible with human rights, a court will say it's incompatible with human rights. This is called a declaration of incompatibility, and the Parliament's asked to look at it again, but the law still stands, unlike in the devolved nations. And of course, it's really important to remember that discussions about human rights, maybe attitudes and approaches to human rights, can be really different in different parts of the UK. Different issues can be in different nations and so on. Okay, so our Human Rights Act works in three main ways, and works the same way regardless of where you are in the UK. So firstly, and really importantly, this is what I said right at the start, human rights are the law, and the Human Rights Act puts a legal duty on public authorities to respect and protect human rights across their actions, decisions, policies and services. So essentially in everything they do every day, public authorities and the people who work for them have to be respecting and protecting people's human rights. Secondly, all other laws should be applied in a way that respects your human rights as far as possible. This little picture on the right-hand side illustrates this. So imagine that piece of paper at the back is any sort of law or policy or guidance. Imagine it's a law that a staff member is using every day. So maybe it's Children's Act or Mental Health Act, whatever it is. They're making a decision based on that law. And what they have to do, what the Human Rights Act says they should do, is look at that law through the lens of human rights. So that magnifying glass is the Human Rights Act. And we're thinking about, okay, I have to make this decision using this law. How can I do it in a way that respects people's human rights? So they can't say, I made this decision under this law, so I had to sort of make a decision against somebody's human rights or make a decision that breached somebody's human rights. They have to be thinking about, how can I make decisions in a way that respects people's human rights? And then lastly, and I've sort of mentioned this before, if these first two things are not complied with, so if a public authority doesn't respect and protect your human rights, or if a law is applied in a way that doesn't respect your human rights, we can now bring legal cases in UK courts. So I said whenever the European Convention and the court system there came about, that was great because people could bring their human rights issues to the court in France. But if we think about the whole of the Council of Europe, there's over 800 million people there. So the court had really long waiting times. It could take years for your case to be heard. And it wasn't very accessible for people in the UK to have to go to France. So now if you think either of these two things are happening, you can now bring your legal cases in UK courts. And UK courts and tribunals can look at sort of human rights issues without you having to go to France. So what does it mean for us? What does this legal duty, this duty in law, mean for us and the people that we support? So it means that we can speak up because we all have human rights, which the law says should be respected and protected. So whenever we're talking about human rights, whenever we're maybe challenging something using human rights, if we're challenging a decision or if we're asking for services to be more rights respecting or whatever it is, sometimes I've had discussions with people before and they feel a bit nervous or anxious to do that because they feel as though they're asking for special treatment or whatever it may be. But as this is the law, all that is happening here is that people are asking for the law to be respected. And we wouldn't really have concerns if we were asking about any other law to be sort of respected and protected. Think about, for example, health and safety law. People would bring up issues saying, no, I think that breaches health and safety law. It's just the same with human rights, it's a law. Also means that we can talk to services about whether they're meeting their legal duty to respect and protect people's human rights. And we've seen sort of in the past that this has been really successful and useful because it takes it away from I agree with you or I disagree with you, or you made a good decision there, you made a bad decision there. And instead, it focuses it on this framework of the law and of rights. And we can instead say, let's look at what the law says, let's look what the legal framework says and make a decision or look again at a decision using that framework. And then we can work with services to find better solutions without the need to go to court or use a lawyer. Sometimes, of course, situations will develop in a way that we do have to go to court and use a lawyer, but what we focus on at BIHR is how can we use human rights further sort of near to the start of situations, or hopefully before sort of bad things happen in the first place, to make sure that we don't have to get to that situation where we're going to court and using lawyers and things like that. So we have 16 human rights in the Human Rights Act. This is them all here. I'm not going to go through them, but I will show you where you can find more information in a bit. And what's really important to think about in terms of these human rights, and this is what I again mentioned at the start about this idea of some human rights being able to be limited and restricted and some not, is this idea of absolute and non-absolute human rights. Absolute human rights can never be limited or restricted or interfered with. It doesn't matter what the reason is, including, for example, resources. And if there is a situation or a decision which is restricting an absolute right, then that's unlawful. So if we go back to the rights, the right not to be tortured or treated in an inhuman or degrading way, for example, that's an absolute right. So as soon as treatment reaches what we call this threshold of inhuman degrading treatment, so that's treatment that's really impacting us, making us feel very humiliated or embarrassed or having a really big impact on our physical health or whatever it might be, that's starting to reach that level of inhuman degrading treatment. Therefore, it's unlawful, and that's a line in the sand. Action needs to be taken very quickly by the sort of decision maker or the public service, whoever it is, to make sure that that person's no longer in a situation which is inhuman and degrading. And then we go to the second group of rights, which are non-absolute rights. These are the rights which can be limited or restricted if a three-stage test is passed. So as I said, human rights are all about this rule book for how we can expect to be treated. They're the basic standards for which we can expect, which means that if there's going to be a decision which is going to impact our human rights, that shouldn't be taken lightly. That's a big deal for the person that is impacted. So we have to think, or the decision maker has to think about this three-stage test. They have to think first, is it lawful? Is there a law which allows me to make this restriction? Secondly, is it legitimate? That's usually set out in the rights itself, but it's about things like, is it protecting that person, so the person impacted by the decision or others, from harm? Is it protecting the rights of that person or others? Or also sometimes it's things like public health, public safety, stuff like that. And then lastly, and really importantly, we come to this idea of proportionate. That's really important. And essentially this comes down to, is has the least restrictive option been taken? So has the decision maker looked at all the decisions that they could make, all the options they could take, and chosen the one which is the least restrictive on the person's rights? If the answer is no, then it's not proportionate. So the decision maker has to think, is this lawful? What law am I basing it on? Is this for a legitimate reason? And is this proportionate? Is this the least restrictive option that I can choose here? So if the decision maker has to be thinking about that, whether that's a decision maker in terms of maybe an individual social worker or a nurse, or maybe a decision maker more widely that's making a new policy, for example, we and the people that we support can ask back to that decision maker, is that lawful? What law did you base that on? Is it legitimate? What was your legitimate reason here? And was it proportionate? And this is often where we can find better solutions for everyone involved, because often whenever we are thinking we want to question the proportionality, we ourselves can also think of other alternative solutions, thinking, okay, this is not proportionate because I can think of this option here, which would have been a less restrictive option on the people that are impacted, or the person that's impacted, or my rights. Okay, so proportionality is spinning around there because it's really important. So as I said, there's 16 rights in the Human Rights Act. That's them all there. And what we've been doing at BIHR has been working on sort of doing a page on our website for each of these rights, explaining the right, seeing if it's absolute and cannot be restricted, or non-absolute and can be restricted if it passes the three-stage test. And we also are providing all that information in easy read as well. If you have any questions, please do email me if you want at that email address there, eturnbull@bihr.org.uk. I'll be more than happy to answer your questions.